Judgment on the Crown's application under Section 5A of the Protection from Harassment Act 1997. These complainants were Rosina Breen, Helen Thomas, Liz Green and Stephanie Hurst. Each of these gave oral evidence at trial. Section 5A of the 1997 Act empowers a court to make restraining orders against the defendant following his acquittal if the court concludes it is necessary to do so to protect a person from harassment. Nothing in this judgment seeks to cast any doubt on Mr. Belfield's acquittal. I am required to consider a separate question under the statute, which is the need for any future protection, even in cases where there has been an acquittal. That will require me to consider the evidence before the jury, but nothing I say seeks to question their verdicts. I am applying the civil standard of proof in identifying the facts, unlike the jury when determining the criminal charges. The court may make orders which are either time limited or indefinite, but subject to the court's powers under Section 5A 2B. At trial, counts 1 to 4 were grouped together because they related in part at least to the time Mr. Belfield spent at BBC Radio Leeds and actions Mr. Belfield took in relation to the BBC employees thereafter. There were many common features of Mr. Belfield's conduct in relation to these complainants, and I will, in the interest of brevity, summarise my findings by reference to the common facts which emerged from the evidence. I will, however, also need to make reference in brief terms to evidence concerning particular complainants. In coming to my decision, I have taken into account the oral and written evidence presented to the jury. I also take into account that the nature of future restraints which the Crown seek will interfere with Mr. Belfield's Article 10 ECHR rights, because they essentially seek to restrain speech and communications. Accordingly, I approach matters on the basis that the need for such future restraints must be convincingly established and the measures must satisfy a strict proportionality test. The court must balance the complainant's rights to a private life under Article 8 of the ECHR against Mr. Belfield's Article 10 rights. Based on the oral and written evidence before me, I am satisfied that the orders are necessary and justified. Each of the complainants require protection from Mr. Belfield. I will explain my reasons. The starting point is my findings in relation to past events. I note that the oral evidence of each of these witnesses was essentially uncontradicted by counter-oral evidence. I also found them wholly honest, impressive and straightforward witnesses who have achieved substantial success in their fields. They were profoundly damaged by Mr. Belfield's actions and they have had to seek assistance from medical professionals. Each of them suffered a campaign of harassment by email and social media communications. Each of them serious mental health problems arising from Mr. Belfield's conduct. The longest periods of abuse were suffered by Miss Breen, Miss Thomas and Miss Green. I find that in relation to Miss Breen, and Miss Thomas, abusive emails running into the thousands were sent over about a 10-year period. In relation to Miss Green, there were hundreds of emails. Apologies. In relation to Miss Hurst, there were not as many emails, but there were highly offensive and transphobic social media posts and videos. I accept the evidence of the complainants that although a relatively small number of emails were produced in court, the policy they had been directed to follow was to delete any emails which Mr. Belfield sent. These complainants did not respond to his emails. They did not engage with him in any way. In short, they did nothing in response to the barrage of communications, yet he continued to target and harass them over long periods of time. I have not overlooked the fact that in many communications, Mr. Belfield was, aside from abuse, also making points on matter of public interest such as BBC use of resources and listening figures, as well as concerns about content. However, in his communications concerning these complainants, he went far and beyond that. His communications were often made to mass email audiences within the BBC, many of whom had nothing to do with the complainants. On occasions, he made highly offensive and personal comments about their physical appearance, including sexualised comments about them. The emails were often blind copied to them. I accept the evidence that Mr. Belfield effectively followed these women by online harassment throughout their careers. Most distressing was that fact that many years after Mr. Belfield had ceased to have anything to do with them professionally, he would email very senior personnel at the BBC with wholly false allegations that Miss Breen, Miss Thomas and Miss Green had bullied him. There was no escape for these complainants from Mr. Belfield until Nottinghamshire Police became involved in late 2020 and bail conditions prohibiting contact or references to these persons were imposed. I find that these complainants were targeted by Mr. Belfield because he held personal grudges against them. As regard Miss Breen and Miss Thomas, his former managers, he felt they had mistreated him during his brief period working at the BBC Radio Leeds in 2010-2011. Mr. Belfield also has a belief that women, as part of what he repeatedly called tick box culture, were being promoted and given prominence within the BBC when he, as a person in his own view of real talent, was not being employed. I express no view as to this, save to say that holding such a belief does not provide a charter for harassment over 10 years. As to Miss Green, he felt she acted inappropriately towards him at a time when she was also a radio presenter at the station. She had continued to work at BBC Radio Leeds when Mr. Belfield's contract had not been continued. As regards Stephanie Hurst, Mr. Belfield felt a personal insult when she declined an interview with him following her gender transition. That turned into a campaign of transphobic behaviour, which at every turn led him to isolate her transgender status and to ridicule her in his comments and videos. I do not accept Mr. Belfield's characterisation of his comments in relation to Miss Hurst as simple parody or comment of comedic nature. They are more accurately described as transphobic and hateful comments. I find they were motivated, in part at least, by feelings of jealousy as to her success when his own career within the BBC had foundered. It is striking that Mr. Belfield found it near impossible to make any communication concerning Miss Hurst without including highly offensive emojis about her transition. In each of these cases, it was essentially a personal campaign of revenge motivated him, as opposed to some form of journalistic exercise of holding people within the BBC to account. Applying the civil standard, I find that Mr. Belfield carried out a historic course of conduct against each complainant which amounted to statutory harassment causing distress and alarm, and that he ought to have known his actions amounted to harassment. I also find that based on the nature and extent of that conduct on his police interviews and the nature of his defence in this trial, that there is very substantial risk that absent of a court restraint he is likely to continue such behaviour. In my judgment, Mr. Belfield's approach at trial did not indicate any appreciation of the extent to which he had damaged the mental health of these four women. An order which is indefinite in time is justified. I cannot, on the evidence before me, find that Mr. Belfield is likely at any particular period in the future to have an appreciation of the inappropriateness of his past actions. The complainant's rights to have a private life outweigh any freedom of speech right Mr. Belfield might claim to exercise. The terms of the Crown's draft orders, as discussed in court, are, in my judgment, sufficiently tailored to go no further than protecting the complainant's Article 8 right to a private life. They are proportionate and strike an appropriate balance. They do not impose any restraint on legitimate exercise of Article 10 ECHR rights. I will make indefinite restraining orders against Mr. Belfield in favour of Rosina Breen, Helen Thomas, Liz Green and Stephanie Hurst under Section 5A of the Protection from Harassment Act 1997. As regards each of the persons Mr. Belfield is, until further order, prohibited from contacting or attempting to contact them by any means, whether direct or indirect. He must not publish through any form of publication or electronic communication any statement or any material relating to or purporting to relate to them. He must not monitor the use by any of them of the internet, email or any other form of electronic communication. Any breach of these orders is a serious criminal offence with substantial criminal penalties which may include imprisonment up to 5 years. Mr. Belfield will be given a written record of the terms of the orders. If for any reason the orders are no longer necessary and appropriate, then either Mr. Belfield or the complainants may apply to the court for them to be amended or removed. But until that time, which may never come, they will remain in force and must be complied with to the letter. Finally, I record that I consider each of these women acted with substantial courage and real fortitude in coming to court to give evidence in a public forum about matters which had very substantial negative mental health impacts upon them over several years. The orders today are intended to provide them with protection with criminal penalties for breach against any repetition in the future of such conduct.